DPDPA or the Digital Personal Data Protection Act is the act that has recently been enacted by the Government of India for ensuring and safeguarding the privacy and protection of the personal data of its citizens. In this video, our objective is to cover the details of the act, its purpose, and its applicability, various key terms, and their importance in relation to the act. Let's proceed. Let's understand what is the actual wording of the act. An act to provide for the processing of digital personal data in a manner that recognizes both the right of individuals to protect their personal data and the need to process such personal data for lawful purposes and for matters connected therewith or incidental thereto. It came into force in 2023, that is, in this year. As we move through the slides in this video, we will get to know more about what this means and how the government plans to regulate this in the country. Before even we delve further, we need to know that this is not the first time any country has incorporated an act related to data protection and privacy. Previously, many other countries have initiated this, and let's go through a few of them around the world. PIPEDA of Canada, the Personal Information Protection and Electronic Documents Act, CCPA in US, the California Consumer Privacy Act, LGPD in Brazil, the General Data Protection Law, the GDPR in Europe or the General Data Protection Regulation. The GDPR is the most popular since it is applicable to all countries that come in the EU, also called the European Union. POPIA in South Africa, the Protection of Personal Information Act, APA, the Australian Privacy Act, the IPP in New Zealand, the PIPL in China, and the PIPA in South Korea, to name a few. Let us understand the primary principles of privacy first to understand this act better. Freedom from interference or intrusion means that no one interferes with your freedom and intrudes into your personal activities. State of an individual to secure and protect their information means that everyone should have the right to keep their personal information secure and only share with people or entities with a degree of confidentiality. Rights of someone to have control over the use of their personal information means that an individual should have full ownership of the purpose of the processing and use of their personal information, and it should not be shared with anyone without their explicit consent. Now that you have understood privacy, let us proceed to understand the concept of the PII or the personally identifiable information. PII is something through which an individual could be identified, or it's something that defines the individual's critical personal details. Let's take a few examples. Date of birth, email address, home address, passport number, UID number, medical or healthcare information, and bank account details are some common examples of the PII, and they are critical and sensitive in nature. Our next step is understanding the purpose of the Act and why the government is doing this. To protect individuals and citizens' personal data, to have stronger regulatory and compliance and laws around this, to incorporate protocols for cross border data transfer, and to enforce individual rights and controls, and also to have a better process for consent management, data processing, and retention. Now let's get into the real business of understanding the key terms in relation to the DPDP Act and their significance and context. Data principle. It is you or the citizen of India, that is the person or individual whose personal data is being discussed here. The data fiduciary is the company or entity which is responsible for using and processing the personal data of the data principal. The consent manager is an individual or a body whose objective is to manage the consent of the data principals to the data fiduciaries for the processing of their personal information or data. Data processor is the company or the entity responsible for processing data on behalf of the data fiduciary. This may be applicable in some cases, and in other cases, the data fiduciary itself may act as the data processor. Data Protection Officer or the DPO is the person who is appointed by the data fiduciary to ensure that the data collected, used, and processed is being done in accordance of the rules and protocols of the Act, and that if there is any deviation or violation, they are responsible to report it as required. The Data Protection Board is an independent body constituted by the Government of India to ensure the rules and sections laid down by the DPDP Act are adhered to, and also responsible to impose fines and penalties where there is a data breach or violation. We will proceed now to know more in detail about them. Data fiduciary. The data fiduciary should only process the personal data of the data principal in accordance with this act. Also, in order to do that, they should have proper and explicit consent from the data principal. Not only that, in addition to the consent, the processing that they need to do should be for legitimate users only. Ideally, the data fiduciary should send a notice to the data principal which should clearly denote the purpose of processing, the manner in which the data principal may exercise their rights, and the manner in which the complaints related to the same may be addressed. Continuing further on the obligations of the data fiduciary may optionally appoint a data processor who could be doing the processing on their behalf. They should ensure that their technical and organizational controls are implemented properly, take sufficient security measures to avoid a data breach scenario, define procedure to delete the personal data when it's no longer required. The data fiduciary should also appoint a data protection officer to govern and maintain the data processing activities in accordance with the Act. The role of the data protection officer will be discussed in more detail in this video further ahead. In case there is a data breach, it is also the responsibility of the data fiduciary to notify the Data Protection Board and the data principals in accordance with the DPDP Act. Next, we will learn about the rights and duties of the data principal. The data principal or the individual should have the right to provide consent to the use of their personal data, right to request correction of their personal data whenever it's required, and the right to request deletion of the same when it's no longer required. The duties of the data principal are that they should comply to the provisions of the Act, always provide correct and authentic information, and shouldn't hide any information related to what is required from them for the purpose of legitimate use of the processing of their personal data. In addition, they should act only for themselves and shouldn't impersonate another individual with an intent to provide false or incorrect information or to cover an individual's true identity. Next term is the data processor. The data processor is the company or entity which processes data on behalf of the data fiduciary. It's required to have adequate security controls in place. in their environment, given that they have this important and critical task of dealing with the personal data processing of citizens and individuals. They should also be responsible, in addition to the data fiduciary, to comply with the provisions of this Act and make enough effort in implementing procedures and controls to prevent data breaches from happening. Data Protection Officer, also called the DPO, is the person who is appointed by the data fiduciary. Their responsibility lies in safeguarding the personal data which is retained by the data fiduciary for processing, ensure that the processing is lawful by all means. The DPO is generally recommended to report to the board of C level executives of the company given the critical responsibilities they own. Consent manager is a person who is registered with the data protection board. So the consent manager is the interface or the point of contact for the data principal to provide, manage, or withdraw consent to the data fiduciary. Consent managers are responsible for managing consent in accordance with the Act. The Data Protection Board. The Data Protection Board or authority is a body constituted by the Government of India. Its powers and functions include investigating the cause of the data breaches and establish evidence, impose fines and penalties to the concerned data fiduciaries or processors as applicable in the Act, and address complaints or grievances in relation to the Act. In the next section, we will discuss the fines and penalties. Prior to that, we need to know scenarios in which the fines and penalties may be imposed. The Data Protection Board investigation may reveal that adequate security safeguards were not in place due to which the data breach happened, or the data processor did not meet its obligations in accordance to the Act, or it failed to provide notification of the breach, which is also its responsibility. In such scenarios, the board may impose a fine or penalty on the data fiduciary or the data processor, which ranges from 50 crore to 250 crore rupees, depending on the trigger and nature of the breach. Let's go through the fines and penalties in more detail. If there is a breach in the data fiduciary's obligation to take reasonable safeguards to protect personal data, then the fine may extend up to 250 crore rupees. If there is a breach in the data fiduciary's obligation to give the board or the affected data principal notice of a personal data breach, then in that case also the fine extends to 250 crore rupees. If there is a breach involving children as per the additional obligations, then the fines range up to 200 crore rupees. If any other provisions of the Act are breached, then the order of fine is up to 50 crore rupees. If there is a breach by the data principals in doing their duties, then the fine that could be levied on the data principal is up to 10,000 rupees. Next on our list is understanding what kind of companies or entities come under this Act. Online shopping and e commerce companies collect personal data of customers, including email addresses, card details, home address, etc., and process that information for delivering services to their consumers. So they come under the purview of this Act. Telecom service providers collect their subscriber details like phone number, email address, UID, or other details, and they process that information. So they should comply to this Act. Banking and financial services companies collect a lot of critical and sensitive personal details like UID, PAN details, financial information, mortgage details, property documents, etc. And they have a big responsibility to use and process the data in accordance with the provisions of the Act. Telemedicine and healthcare companies collect patient information and critical personal details for providing consultation services as well as other medical services, which makes it imperative for them to deal with the personal data they collect with utmost care and that it shouldn't be breached and shared with any person who isn't authorized to receive it. Hence, they are very much covered under this Act. Real estate broking agencies provide rental, mortgage, and selling services to their customers and in the process collect various personal details from them. The DPDP Act is hence also applicable for them. While big companies would have to comply to the same in 6 months' time, the smaller companies would be given a 12-month timeline to fulfill the same and to be compliant to the provisions of the Act as per the directions of the government. Exemptions under the Act. Not all personal data processing would come under this Act, and there are obviously some exemptions. What are the exemptions from this Act? Let's then discuss through. Legal right or claim. Whenever there is an enforcement of legal right or claim, then of course the personal data processing is required and is exempt from any fines or penalties thereof. Non residents. When the personal data of the non residents of India is involved, it falls into the exempted category since the individual is already in the jurisdiction of the respective foreign country they reside during that time. Mergers and acquisitions. When two or more companies merge with each other or demerge from each other, in those cases, the personal data processing is also exempt as long as there is a valid agreement for the purpose of such processing and under the legal or other regulations of the mergers and acquisitions. Judicial or regulatory. When the data is processed for judicial and regulatory purposes as required by the laws and under the legal framework, the use of such processing of personal data is also exempted from the purview of the DPDP Act. This was an introduction to the DPDP or the Digital Personal Data Protection Act of India. Thank you for coming this far in this video, and I hope it was useful for you to understand the Act, its applicability and purpose, the key terms, fines and penalties, and the exemptions in more detail. Stay tuned for more interesting videos and provide your support in the objective of knowledge sharing and learning. Have a nice day ahead.